In 1984, a vacancy occurred on the Court of Appeals of Tennessee, and you were appointed to that position. First, describe the process leading up to your appointment, and then describe some of your more memorable experiences on the court during the first few years.
The vacancy came open when Lou Connor, who was on the Court of Appeals, decided to run for governor. He later decided not to run for governor when Winfield Dunn announced, but Lou decided he was going to leave, so he called me one day and said, you know, I'm leaving, I'm going to run for governor, you ought to apply for the job. And I just said, well, I don't really, never thought about being a judge. I kind of like what I'm doing here. And as a matter of fact, we're now getting closer to the end of Alexander's term, and I had been interviewing with several law firms in Nashville and actually had received an offer from a firm. So I said, well, Lou, I'm not, you know, it's a great thing, but the timing's not right. And Lou's reaction was, look, you do that for 2 or 3 years, it'll increase your price when you go into private practice. And I just said, I'm just really not sure that's what I want to do, but I thought about it some and then called the firm that had made an offer and said, would you mind if we deferred this while I apply for the Court of Appeals? And the firm said no, so I applied for the Court of Appeals. Of course, you know, there was merit selection back then, so there was a selection panel. Victor Ash's mother was on the selection panel. Fred Thompson was on the selection panel. Frank Gorell was the chair of the panel. Bill Willis was on the selection panel. And, but knowing that I had a very untraditional career trajectory, I figured that the chances were very slim that I would get out. Much to my surprise, I did. The front runner was Judge Swigert, Jim Swigert, who you know, certainly was a wonderful judge and would have made a wonderful Supreme Court justice. But I made it into the final 3, and I guess Alexander had decided he had had all the fun with me he could stand, so he appointed me to the Court of Appeals, and I moved across the street.
You returned to the same building where you started your legal career. What were some of your more memorable experiences on the court during the early years?
Well, I'll tell you, the first experience was getting used to being one judge on a multi-judge court. And I was very fortunate to have colleagues who were understanding by and large. You know, Ben Cantrell was just a wonderful colleague and helped show me the ropes. Sam Lewis, another wonderful guy, was very kind to a young judge. Henry Todd was the presiding judge, and there was an age difference between us, very significant, maybe 40+ years. But Judge Todd tried in his professorial way to show me the good from the bad and the right from the wrong, and we got along by and large fairly well. One of the things that Judge Todd did for me, he probably didn't intend to do it, but I was an inveterate smoker back then, and you know, pipes, cigars, cigarettes, would carry all kinds of tobacco on my person, and my office was right next to Judge Todd's, and Judge Todd, after about 6 months, came in and told me that he was allergic to tobacco smoke. And you know, I asked him if he wanted me to move the office, and he said, well, there's no other office to move to, so I used that as a reason to quit smoking. So Judge Todd, I will owe him to this day the credit for getting me off cigarettes in 1984. But the early days of the Court of Appeals was something where generational issues just had to be addressed, and different worldviews had to be discussed, and I was lucky to have some very patient folks that let me work some of those things through.
Early in your tenure on the Court of Appeals, you decided to obtain an LLM in judicial process from the University of Virginia School of Law. while fulfilling your responsibilities as a full-time judge on the court. Why did you seek that degree, and describe that experience and the difficulties of going to school and working at the same time?
Well, I'm glad you asked me that. And the University of Virginia had this LLM program for years. And the only other two Tennesseans that had gone through it were Tommy Wiseman on the district bench and Jerry, I'm blanking on his name, on the Court of Criminal Appeals. Long retired. But there, one
Sutton?
state judge, one federal
Was
judge.
it Sutton? No.
No.
Okay.
And when they accepted classes every 2 years.
Scott.
Jerry Scott, thank you.
Sorry.
They accepted classes every 2 years because it required study in Charlottesville for 2 summers. And Jerry Scott suggested that I ought to do it. And so I decided I would do it. Scholarships were available, so the state didn't have to pay for it, and I didn't have to pay for it. And the reason why I wanted to do it was that it was a master's program that focused on the art of judging. You know, how do you decide cases? How do you apply law to facts? And they limited the class to 30 state and federal appellate judges from around the country, so there was a lot of cross-pollination about how different courts approached issues and things like that. And you know, I knew it wasn't going to lead to any more salary. It wasn't going to lead to a higher office. It was not a credential that necessarily would be marketable anywhere else. But it was an opportunity for 2 years to go to school with not having to worry about grades. Now, we had to matriculate. We were regular students. We were graded. But it wasn't like I was worried about getting another credential so I could get my first job. It was purely for the challenge of learning, and learning with some of the best law professors in the country at UVA, and having in class just superb state and federal judges to basically live with for 2 summers talking about law. And so what I got of that, as much as anything else, was really getting my batteries recharged for what the appellate process is. It was absolutely wonderful, and then unfortunately the money for the program dried up. It's just recently started again at Duke, and there were some states who made an effort to make sure that every one of their appellate judges had an opportunity to attend the program, but in Tennessee it was not one of those things that was that high a priority.
In 2003, you became the presiding judge of the middle section of the Court of Appeals, and you continued to serve in that position until 2007. Please identify some of your more memorable experiences on the court and the more significant decisions you authored.
Well,
and I know there were thousands.
You know, you're kind of like asking me to name your favorite child. You know, that each one of these decisions was something, as you very well know, because you do the same thing, you take very seriously when you're doing it. And some enterprises are more successful than others, and in a lot of ways you just have to leave it to the readers to decide whether you accomplish what you set out to accomplish. If you're talking about decisions that have a place in my mind, it's not necessarily because they're significant, but for example, there was a case I decided called In Re Conservatorship of Groves. It's about mental capacity. And at the time that I got assigned that case was at the same time that my mother had been diagnosed with Alzheimer's. And so I was getting very immersed in dementia and issues of capacity. And that decision, of course, I tend to write more than I needed to sometimes. That decision might be longer than it needed to, but it in some ways it reflected the path I was walking down as a person and a judge, learning about a set of circumstances and the legal consequences that go with those circumstances that apply to that case. So conservatorship of Groves is one. Another one that really ended up being something that at the time we didn't think was going to necessarily have the marquee value it ended up having, was a lawsuit by the Daughters of the Confederacy against Vanderbilt over the naming of the Confederate Memorial Hall at Vanderbilt. And it was surprising after that opinion came down how much debate and discussion there was about it. But the interesting thing about that was not so much my opinion, I wrote the majority opinion, but Judge Kane, one of my dear colleagues, wrote a concurring opinion in that case that spelled out eloquently the fact that not all persons who fought for the Confederacy were fighting for slavery or had slaves, that they were fighting for their home. And as late as 6 months ago, I got a call from somebody about that opinion. So it still resounds out there. And so there were a number of things like that that just touched on issues that as an appellate judge you think are fairly routine. You only find out later that they had much more significance to the parties or to others on the periphery of it than you ever thought.
I'm proud to say that I was blessed to be on that panel. And after reading your majority opinion and Judge Kane's concurring opinion, I was smart enough to do nothing more than concur in both. Let's go back to 1990, in the interim, as lawyers like to say. When you founded the first American Inn of Court in Tennessee, the Harry Phillips Inn of Court in Nashville, what gave you the inspiration to do that?
Well, let me correct you just a little bit. The first Inn of Court, actually, Riley Anderson founded in Knoxville, the Hamilton Burnett American Inn of Court. And this was at the time when the American Inns of Court was in its infancy, and Riley, being the precedent setter that he always had heard about that from other judges. So he had started one in Knoxville. A group of lawyers went to Tommy Wiseman here and said, we'd like to start an Inn of Court in Nashville. And Tommy decided that rather than take that on himself, he was going to call some of the usual suspects to be a founding committee. So, he called me, we called Charlie Warfield and Alan High and several other folks, and that committee got together to start the Inn of Court. And it's essentially intended to be a gathering place and a mentoring opportunity where lawyers of different stages of their profession can pass on the importance of civility, excellence, and professionalism in the practice of law without getting into political questions, without worrying about whether they're plaintiff or defense, whether they're whether they're in private practice or government practice. And like lawyers, we set this up, and then we figured it's probably not going to last. So we won't tell anybody about it. We won't make a big splash because it's probably going to be very short-lived. And now we're sitting here 25 years later, and the Harry Phillips American Inn of Court is going just fine. We now have a second Inn of Court in Nashville at Belmont. We have an Inn of Court in Franklin, Tennessee, and in Murfreesboro, and in Chattanooga, Jackson, and Memphis. And the persons who started those are local lawyers and judges who have the same commitment that the lawyers and judges here and in Knoxville had to restore the nobility of the practice of law. And I've just been very fortunate to be a part of that.
For those who may not be familiar with the Inn of Court, would you share with them the origins of it with Gray's Inn, Lincoln's Inn, the Inner Temple, and the Middle Temple in London, England?
Well, the traditional way that barristers were prepared to practice in England was through Inns of Court, and they were communities, persons, senior lawyers, judges, and junior lawyers who lived together, ate together, and studied together, and passed on not only the substantive legal knowledge, but the skills needed to be an effective advocate before the bar in England. Chief Justice Warren Burger in the mid-'70s was on an Anglo-American exchange and got the idea that this inn-of-court concept could be molded and transplanted to America, although obviously we have different ways that we approach legal education. And so he assembled a starting group of federal judges to replicate the experience in the United States. And the first American Inn of Court was actually started in Salt Lake City, Utah, 35 years ago. And from that, it's spread out now. There are American Inns of Court in 48 of the 50 states. There's an American Inn of Court in Tokyo, Japan. At any one time, I think we have over 35,000 active members of the Inns of Court. There are, in Tennessee right now, there are around 600, 650 lawyers and judges who are active members in Tennessee's courts. And they meet on a monthly basis, sometimes 6 months a year, sometimes 8 months a year, and have CLE programs focusing in on legal issues in the practice of law. You know, and as late as, our inn had a holiday party last week where we invite the former members as well as the active members, and the consistent thing that you hear from people is, I enjoy being in this inn because I get to meet people who are practicing in the profession that I would probably not ever run into in what I do. And so it helps all of us keep our horizons broad rather than just get focused in on that one little niche that we have.
After 10 years of promoting and overseeing the Inns of Court in Tennessee, directly and indirectly, you were selected to the National Board of Trustees of the American Inns of Court, and you have served as its secretary and on the Leadership Council for several years. Tell us about your experience on the National Board.
Well, the National Board consists of federal and state judges from all over the country and very distinguished lawyers in various fields from around the country, and they share the common, we all share the common belief that the practice of law is a noble profession, and that when done well and done right, it's a force for good. And the national organization exists to promote and serve local organizations. The real work of the Inns are not done nationally, like the American Bar Association, who's a wonderful organization in and of itself. Our work's done locally. You know, each inn has between 60 and 100 or so members, and it's that interaction among the members locally that raises the tide of the quality of the practice in the local bar. And our job as a national board is to create more inns and to provide whatever support and assistance we can to the local inns to help them fulfill their mission. They've just recently kicked me upstairs to vice president now, so you know, I'm looking forward to continuing that organization for as long as they'll have me.
Could that elevation be related to the fact that you were selected to represent the United States of America in a debate against the opposition from Great Britain to discuss the proposition that this House believes that the Declaration of Independence was an illegal document? And as I understand it, you prevailed in that debate.
Well, I'm not sure my election to vice president caused that, but my invitation to be on the American team was a result of being in the American Inns of Court. To a lawyer and a law school dean from Philadelphia invited me to be on the American team. And quite frankly, I mean, we worked really hard at coming up with legal arguments to support the legality of the Declaration of Independence under British law. We also practiced very earnestly on being good losers, because this debate was going to occur in the Great Hall of Gray's Inn, and it was going to be before an audience of about 500 or 600 English barristers. And we knew that no matter how they decided to vote, that we were going to lose. And they actually had the strict rules of Cambridge rules of debate we were going to use. And And so we practiced very hard making our presentations, and then we also practiced being gracious losers. And right before the debate started, the master of the debate, what we thought were going to be just the obligatory announcements introducing the persons, and he changed the rules. So instead of a show of hands at the end, he called for a voice vote, and we won by a voice vote. And our British counterparts were very gracious in defeat. And the great thing about debates in the Inns of Court in England are they're followed by lengthy cocktail hours and a big dinner. And so we're all still friends. We've also offered to come back and do it again if they would like to argue it a second time.
After serving on the Court of Appeals for many years, an opportunity arose for you to apply for a vacancy, actually 2 vacancies, that did not occur at the same time on the Tennessee Supreme Court. Tell us about the first and then the second.
Well, you're right. I guess I'd been on the court 22 or 23 years at the time. I know that the sands of time are running through the hourglass of my career, and my opportunities to serve on the Supreme Court were going to be fewer and far between. So when the 2 vacancies occurred, I applied for the first one, and actually for the first time there were 2 selection processes, and the first time I got on the list of 3, the governor asked for another list of names, and I was not on the second list of 3, so I didn't get the first one. And I figured that was probably the last shot, that I would enjoy being on the Intermediate Appellate Court. I would be happy to continue to do that. But then when the next vacancy came up, it was something a little bit more than this, but I already had the lengthy application filled out, so I wasn't going to have to do that again. And several people that were close to me said, the worst they're going to do is say no. You've got a good job. If you still think you'd like to do that, you ought to apply. And so I figured I would apply. Now, a number of folks were saying, well, why are you bothering? Because the governor who will make the appointment is a Democrat, and you're not perceived as a Democrat, so why would you think you'd have any possibility of getting that job? That's a very valid observation to make. And I have now been in Nashville in Tennessee long enough to know that there's a perception that you dance with who brung you. And so if the person that hired you is a Democrat, you must be a Democrat. Or if the person that hired you is a Republican, you must be a Republican. And I guess I'm a little bit of a mixed breed because David Pack was clearly a Democrat. The 4 attorneys general that followed him that kept me on were all Democrats. And so, a colorable argument could have been made, well, I must be a Democrat. But then all of a sudden I go to work for a Republican governor. Well, what does that mean? And what I can tell you is that none of those 5 attorneys general and Lamar Alexander never asked me what my political party was. That subject never came up to me directly. Now, indirectly, I asked a time or two, and for the circle of our mutual friends that I knew they might have talked to about me, all of them have said that question about political persuasion never came up in the process. So when I was deciding whether I was going to put my hat in the ring for the Attorney General, for the Supreme Court one last time, I didn't know Governor Bredesen personally. I knew of him. I had some professional dealings with him. And I just said, he's going to call the balls and the strikes the way he sees it. I don't think he's going to consider politics, but it's not going to be the tail that wags the dog. So I'll go ahead and apply. Of course, that was the most snake-bitten vacancy to get filled because it ended up that lawsuits were filed. The governor believed that the selection commission was was throwing spitballs at him, so he had to sue the commission to try to get a clarification on what the law meant and what kind of panel he was entitled to. And I think we eventually had to redo that selection process as well. And when the three names came up, it was a fairly controversial list of three names because, well, there was a Republican on there, which people just didn't understand. That was me. And so the process between the time that the announcement of the vacancy and the time it finally got filled was a year or more, a little over a year. And there was just a lot of stuff going on behind the scenes that I was mercifully unaware of. But then I remember it was the week of a judicial conference. It was the week of the Tennessee Bar Association meeting out here at the Marriott, and I got a call saying you ought to be available for a phone call. That's all the call was. Now, understand, I've had to make calls before telling people they're not getting judgeships. That's what the Council of the Governor does. The governor always gives the good news. The staff always gives the bad news. And so the call didn't say who was going to be making the call, just you ought to be available for a call. So I decided I was just going to be in my office up on the second floor, because if the answer was going to be no, I'd rather just be there, get it personally, and not worry about it. So I was not out at the conference. And at about 8:30 in the morning, it was like a Thursday or a Friday, the phone rings. My longtime assistant, Susan Doolin, picks up the phone, and she says, "Yes, Governor, just a moment." Well, I've been there, done that. This is going to be a good call. And so I pick up the phone. It's Governor Bredesen. He is very gracious. He offers me the position, and then he says, "I would appreciate it if you would not say anything about this to anybody until we have a chance to notify the other two people and we get the press releases out." And I said, "Of course, I won't say a thing." And I said, "Well, can I call my wife and tell her?" And he says, "Well, you can tell her." So I tell my wife, and then I'm sitting there doing nothing. Of course, what's happened now, the call has gone out to the other two. They are at the convention at the Marriott. And so they've got the call, and so he said no to me, and the other person says, "Well, he said no to me." Well, there's only one other choice. So the word is going around the convention that Koch must have got the appointment. The next call I get is from a lawyer friend of mine who is at the convention, and he says, "I'm not going to ask you to confirm anything or not, but the word is that you got the appointment." And I said, "Well, you're right. I can't say anything one way or the other." And he said, "Well, I've been standing out here in the lobby at the coffee urn. I've been listening to conversations going on." And he said, "You need to know this one conversation." I said, "Well, what's that?" And he says, "Well," he says, "one lawyer said to another lawyer, 'I can't believe that Bredesen would appoint that damn Republican to that job.' And the response from the other lawyer was, 'Well, he's not much of a Republican.'"
You took the oath of office for the Tennessee Supreme Court on June 22, 2007, after serving 20-plus years on the Court of Appeals. You begin your new duties immediately. Describe your experiences on the Supreme Court and how they differed from your responsibilities on the Court of Appeals.
I'll answer that question, but let me give you one footnote to the last answer. At my investiture for the Supreme Court, one of the speakers was the Chief Justice, Mickey Barker. And for all of us that know Justice Barker, he has a turn of the phrase. And I've just told you about what transpired when the governor called me. Well, cycle back to his first appointment to the Court of Criminal Appeals. Alexander appointed him to the Court of Criminal Appeals. I was in the office the day that Governor Alexander offered Justice Barker the job. And of course, Justice Barker accepted the job, and then he and I walked back to my office to do the paperwork, and I explained to him, I said, now this is the governor's appointment, not yours, so you can't tell anybody about this until we issue the press release. He says, well, when do you think that's going to be? And I said, well, it could be this was like middle of the week. It could be the first part of next week. I said, you just don't need to talk to anybody. He says, I'll move to a motel down in Georgia. I said, that'd be a really good idea. So Justice Barker goes home. He is saying nothing to anybody. Of course, the rumor mill is now starting that he's going to get the job. So I call him up and I say, I thought you weren't going to say anything about it. He says, I haven't said a thing. I have moved out of town. I haven't talked to a soul. And I said, well, the talk's getting awfully strong coming from the Chattanooga area that you've got the job. And I said, you just need to remember that the governor hasn't appointed you yet. So when I was sworn in to the Supreme Court myself, Justice Barker's remarks, which was before I took the oath to the Supreme Court, Justice Barker looked at Governor Bredesen and said, Governor, you haven't sworn him in yet. But now in terms of the difference in the work, the two differences, most significant differences, are first, Supreme Court justices have a much more significant administrative ribbon-cutting set of responsibilities than intermediate appellate court judges do. So there's liaison to the committees, public face of the courts and various functions, work with bar associations and other legal groups, where there's an expectation, and rightly so, that justices are going to be involved. So the first difference I had was rebudgeting my time, because quite frankly, I was enjoying spending most of my time on court work. Now I had to break out a portion of that to do administrative and things like that. The second difference, and it may sound insignificant, but it's really not, on the Court of Appeals, as you know, all you have to do is count to two. If you want to get a case decided the way you want it decided, you just have to bring one person. On a 5-judge court, you got to count to 3, and that's harder. So the subtle difference in the dynamic of going from a 3-judge court to a 5-judge court was something that was somewhat of a surprise and really took some getting used to. Again, we all, as you know, we try to be unanimous when we can. Appellate judges, it's easier to concur than it is to write separately or dissent. There are just occasions when you have to. So the challenge of trying to produce a draft opinion that is going to be acceptable to your colleagues, or at least 3 of them, was trickier than it had been on the Court of Appeals. And I think part of that, too, was that on the Court of Appeals, many of us worked together for a long period of time. We worked on the same floor in the same building. We ate lunch together. We knew each other. We saw each other socially. We had some history before we were on the court. And that kind of personal connection helps in the decision-making process. On the Supreme Court, we're required to be from different grand divisions. We're not all in the same building. We do a lot of our work by video conference, and while video conferencing is very efficient, in my mind, it's not a complete substitute for the personal interaction of sitting with someone around a table trying to work something out, or being able to walk down the hall to somebody's office and say, I'm kicking this issue around, what are your thoughts about it? So the distance, the geographical distance, and the number on the Supreme Court made the decision-making process a little bit trickier.
I recall you saying that the first day or two you were on the Supreme Court, the number of emails you received were almost 10 times the number that you would typically receive on the Court of Appeals. Why was that?
Well, and I love lawyers. I really do. But you know, we work in a hierarchical system. So when you get to the Supreme Court, you all of a sudden discover you've got a lot of people that are your best friends that you never really knew. So there would be a lot of emails from members of the bar about things that we need to fix this, we need to fix that, or there'd be emails from the administrative office of the courts, or we'd have pro se litigants or clients who are unhappy with their lawyer that would go through whatever sources were available to them and find an email address and would think nothing about sending an email to a justice saying, my lawyer won't return my call, can you fix that? And you know, again, we're all in the business of trying to fix things. I had to learn in fairly short order that it was really probably not a good idea for me starting to helping out clients having their lawyers return their calls.
Can you identify some of your more memorable experiences on the Supreme Court and some of the more significant decisions you authored?
You're back again. Intermediate appellate courts, certainly the Court of Civil Appeals, we had rarely had any capital case issues. You know, there was a couple while we were on the Court of Appeals about the death penalty, but we were really just kind of a cog in a wheel. And moving to the Supreme Court, I was confronted after many years with having to deal head on with the issue of not just guilt or innocence, but life and death. And so the protocol of the court convening on the night of an execution to be ready to respond to pleadings that are filed, I found that process fascinating in the way that it's that sort of environment where you really find out what your colleagues are made of. You know, it's like you're in the trench. And I'm probably being politically incorrect when I say this, but I'm going to say it anyway, that one of the experiences I remember most was the first death case that Chief Justice Sharon Lee served on when she was on the court. And up on the third floor, most of the lights of the building are off, the clerk's lights are on, our office lights are on, and we're sitting up there, and Sharon had been on the eastern section of the Court of Appeals. You know, I had not done that much work with her. But that night I learned what she was about. And part of being an appellate judge is knowing your colleagues and knowing what they're about. And you want to do that not to manipulate them. You want to do that in order to avoid making it hard for them to agree with what you're trying to say. And so one of the challenges, or one of the opportunities that the Supreme Court gave me, but the Court of Appeals did too. I had so many wonderful colleagues on the Court of Appeal. Was getting to know people in a far more deep professional way, you know, where personal values came into play, where ideas, rights and wrong, justice came into play, and that, you know, rather than picking out a particular case, it's that part of the process that I think I remember more than anything else.
That's wonderful. What some people may not appreciate, and if I'm incorrect, please say so, that on the night before executions are scheduled, the Supreme Court justices would literally be in this building, and you would have pizza brought in and what have you, and you would wait until the wee hours of the morning for a last moment appeal.
That's true. Now the protocol changed over time. It's not quite the same way now, because one of the reasons was that the date of the time of the execution was moved earlier. Doesn't happen in the early hours of the morning anymore. But yes, dinner would be brought in. We would be here. time would pass. Sometimes lawyers would submit a flurry of papers. Sometimes they would submit nothing. But the part of it that was unavoidable was that you knew why you were here. You know, and there were several occasions I know where the Court of Appeals and the Court of Criminal Appeals were down on the second floor doing the same thing. You know, it just depends on what avenues the attorneys were trying to pursue. But it's for those people that might think that judges, by virtue of what they do, become so callous that they don't realize the consequences of what they're doing. It's nights like that that put into very sharp relief the fact that judges are profoundly aware of what they're doing, and they approach it not just seriously, in some ways they approach it reverently.
In 2013, you're on the Tennessee Supreme Court, and in approximately a year or a year and a half, you're scheduled to become the next Chief Justice of the Tennessee Supreme Court. But former Chief Justice Frank Drewota, now a trustee of the Nashville School of Law, approaches you about becoming the Dean of the Law School. What were your initial thoughts, and why did you decide to pursue and then accept this new and different responsibility, realizing that you would have to resign from the Supreme Court and pass on the opportunity to be Chief Justice?
Well, part of what I'd been fortunate to be able to do while I was on the appellate bench was teach law school. And I taught at Vanderbilt, taught at Belmont, had taught for 15 years or so at Nashville School of Law. And so I think, like a lot of lawyers and judges, teaching's something that we take on naturally. That doesn't mean we're good at it, but we like to do it. My career is not unfolding the way that I had anticipated, but I anticipated that I would end my career on the Tennessee Supreme Court. And if my colleagues had held their nose and elected me Chief Justice, I guess I would have been Chief Justice. And that would have been great. I was enjoying what I was doing. It was not a question of being burned out or just looking for something else to do. And as you say, Justice Drewota floats this trial balloon, and my first response was, it's a great opportunity, but it's too late. I'm an old guy, and what the school needs is a young guy. And so I kind of, I told Frank I was very flattered and honored but I just didn't think that was going to work. And he came back another time or two, and he said, well, we think about that. You're not as old as you think you are. And, of course, he says, I'm 76 or whatever he is. And so eventually I talked to Debbie about it. Debbie was leery about it because she thought that I was so ingrained at judging that I would have a very difficult time uncoupling and doing something else no matter what it was. But we would talk about it, and the more we talked about it, she finally said, every time you bring up the subject, your tone of voice changes, your body language changes, the sparkles in your eye. She says, you don't have to talk me into doing this. You've already talked yourself into doing this. You ought to do it. And that's when I realized that that's right, that this opportunity had presented to me. It was not something I had sought. It was not something that I could have contrived. But if I'm thinking about what use can I put my remaining time as an active lawyer to that would be worthwhile and valuable, what better use than going to law school and helping an institution that's been around since 1911, training superb lawyers to follow career paths from courtrooms to boardrooms to height of business success. What better use of my time than helping them fulfill the dreams that they have to become lawyers? So I just, I just finally said, this really is what I need to do, not that I want to do. I really need to do it, and the rest, as they say, is history. The board held their nose, offered me the job, I accepted, and I'm still allowed to come to work every day.
It was an interesting process. Almost 10 months transpired from the first conversation with Justice Drewota and the announcement that you would become the dean. And during that time, only 5 trustees and the then dean knew about it. You and obviously your wife and probably your right hand, Susan Doolin. And it was kept confidential for that entire 10 months, even from your colleagues on the Tennessee Supreme Court. That's almost unheard of in the day of Twitter and Facebook and what have you. But explain why it was necessary to maintain that confidence.
Well, I'm not exactly sure what you're getting at, but the important...
Well, the issues of the Supreme Court justices were coming up for
Gotcha.
election and these other, and the big initiative about reform of the process.
Right. The shots were already started to be fired about the selection of the court in 2014. And there had already been some preliminary skirmishing in the evaluation process, and so all the signs were there that this was going to be a little bit of a different sort of retention election in 2014. And we knew that there was going to be partisan overtones to it. And again, the perception was that there was only one, quote, Republican on the Supreme Court, and that person was me. And an announcement that I was leaving could have an unanticipated effect on upping the ante or the tone of the debate about who ought to be on the court. And so there was a consensus that it would be better to wait to publicly announce this until the time for qualifying deadlines had passed, when there was no more time to introduce more legislation to complicate the process. And there was also, the other thing that went into this was that I really didn't want to leave my colleagues shorthanded, and so we wanted to have sufficient amount of time where I would have been able to complete most of the work. And even though different states do it different ways, what Tennessee has consistently done on the Supreme Court is that they assign you cases right up until the time you leave. So I was taking case assignments up until June, before I left in July, and so we wanted to just make sure I wanted to make sure I was doing my share of the work, but we wanted to avoid making what we anticipated was going to be a complex election process more complex by having me out of it.
The announcement was given in December that you would become the next dean of the law school and that you would be resigning, and you gave your colleagues 8 months to transition, which was very gracious. When you became the new dean in 2014, you became the dean of a law school founded in 1911. It was 103 years old when you got there, and only 4 people had been the dean prior to you. Thus, their average tenure was 27 years. I trust you anticipate serving the same amount of time.
Well, actually, that, as you well know, is part of the discussion, and as long as my physical and mental capacities will enable me, I'll be at the Nashville School of Law. But I do understand that sometimes the mainspring begins to wind down, but it is far from winding down right now.
I am honored to be a trustee of the Nashville School of Law, and I'm just exceedingly pleased with the contributions you've made to our school in the year and a half you've been there. Can you describe your experiences thus far as the Dean of the Nashville School of Law and the future you envision for the school?
Well, as you've mentioned, the school's been around since 1911. We are the last of 19 schools started by the YMCA all over the country. We are the last remaining freestanding school like that offers education to men and women at night. And we have a history of pride in that, and as well we should. And so that part of it's not going to change. We exist to give folks an opportunity to study law and get a law degree who would not otherwise be able to do it by going to a full-time day program. So that's going to stay the same. In terms of changes, law schools have to change with the legal times. We have to reflect the environment that we're training our students to enter. And so in the last year or so, and it will go on for a while more too, I think, we're reevaluating the curriculum to make sure we're teaching the right courses in the right way. We're deciding whether we ought to add new emphasis on particular things, experiential learning, clerkships, internships, those sort of things that really help young lawyers figure out what the practice of law is all about. We have a superb faculty, and in the last year and a half that I've been at the school, in those rare times where I've had to recruit faculty, I have shot high and no one has ever said no. So the challenge will be to maintain an excellent faculty that has a balance of academic expertise but real-world skills. We've done polling in the last year and a half among the bar and the public about the impression of the Nashville School of Law, and one of the things that is consistently rated the highest is the quality of the faculty. We have federal judges, state judges, local judges, appellate judges, practitioners matter of fact, a student mentioned this at an alumni gathering the other day. How many other law schools do you go to where your professor says, let's talk about Rule of Evidence 817, here's the way I applied it today? And so it's that wonderful mixture of practical skills and academic skills that is part of our tradition, and I want the school to double down on that. We want to do that better. We want to have a reputation that NSL graduates are practice ready. And so that is a mission that the school has. Where our last two classes have been larger than classes we've had in 10 years, so we're not experiencing the same sort of application decline that many other law schools are experiencing. The credentials of those last two classes are higher than they have been, so for those people that say, well, you're just giving everybody a chance to go to law school whether they can succeed or not. No, we're still being selective about who we give an opportunity to go to school for. But they are like the students that went to school 20 years ago, 40 years ago. The students that enter our school are grateful that they're getting a chance to change their lives to be a lawyer. Many of them have worked for decades to get the stars in alignment to where their job is set, their family is oriented, their finances are okay, where they can come back and on top of juggling family responsibilities and job responsibilities, they can now go to law school 2 or 3 nights a week, spend their weekends studying instead of going to kids' ball games or the movies. And when we have our first year orientation, I'm amazed at the number of people that come up to me and thank me, one of them this year in tears, for allowing them to realize a dream they had worked on for 20 years to go to law school. And so when people say, well, you were on the Supreme Court, while you were up there at the top, why would you want to walk down the mountain? Well, that's why. I haven't walked down the mountain. I'm on the top of a new mountain. And when you look around the state, the Nashville School of Law graduates are practicing in 93 out of 95 counties in Tennessee. In some counties, every lawyer in the county is a Nashville School of Law graduate. the Nashville School of Law is a part of the legal traditions and history of this state, and my mission as dean is to make sure that it maintains being an integral part and to even a greater extent, even do better than we have.
One subject I have not addressed is the many legal articles and publications you have authored, which are numerous and significant. Would you like to discuss some of them?
I'm not sure how significant they are. There might be numerous. Well, actually, one of the last articles that I did was actually with Jeff Kinsler, the dean at Belmont Law School, where we were trying to dispel the myth that there aren't jobs available for lawyers in Tennessee anymore. And you know, we assembled a lot of data from the BPR and from where lawyers are, their ages, the case filings in counties and all that sort of stuff. And I think we demonstrated pretty well that there are wonderful opportunities for lawyers in Tennessee. Now, it may be that Nashville might be a little bit over-lawyered, given the capital, we're the capital city. But if you look to the counties that ring Nashville, Rutherford, Sumner, Wilson, Williamson, you even go farther out to Cookeville, Sparta, places like that, there are real opportunities for lawyers to do real good in their communities. And when I say good, I mean they'll do good work, but they can also do well. There are economic opportunities there as well. And if you look at the retirement ages of lawyers, for example, in Chattanooga, the Chattanooga bar, on average, is older than many other metropolitan bars. Well, that means that people are eventually going to be retiring, and so there are opportunities there. So one of the last articles that I really enjoyed writing was saying there is a market for lawyers in Tennessee for lawyers who are entrepreneurial and are willing to go out and work for it and find it.
One last question. Realizing that a lot of people will see this tape, and one person most certainly will, Debbie Patterson, Koch. Let me give you an opportunity to briefly talk about the love of your life.
You saved the hardest one for last. When I was sworn into the Supreme Court, I guess Debbie and I had been married at that time about 25 years. And independently, of course, you have to write your speech that you're going to give to accept it, and I'm going to have to mention my wife because I would not be who I am without her. And of course, Debbie is a professional writer, and so she wants to review the speech, fix it up for me. And I say, you're not going to look at this speech. I'm just going to give this all by myself. I need to know what you say, and I wouldn't let her say it. So she calls my assistant, and says, Susan, would you just slip me a copy of this speech? And Susan says, you know, there's a lot of things I do for you, Debbie, but I'm not going in there on his computer and ripping it off. I can't do it. So Debbie is trying to figure out what I'm saying in that speech. And what I said in that speech was that she was the sun of my days and the moon and stars of my nights. I apologize. And so I got up in front of God and everybody else, and I said that. And of course, she's sitting right there in the front row, and it's hard to kind of say that. What I didn't know was that completely independent of that, Debbie knows I'm a fountain pen collector, and for my swearing in, she had bought me a collector's fountain pen, a beautiful enameled fountain pen, that on the cap of the fountain pen, which is in cobalt blue, are the moon and the stars. And on the barrel of the fountain pen, which is bright red, is a flaming yellow sun. And she had bought that because she wanted me to sign the oath. After I took the oath, the governor and I were going to sign. She wanted me to sign the oath with this pen she was going to give us. So here we are, we're both on the same track, Moon and Stars. Well, the room was so filled with people that she couldn't get over to the podium in time to give me the pen. So Governor Branson and I had already signed the oath using his pen. And then she hands me the pen. She and I had looked at it in a store window in Washington 3 years earlier. And she hands me this pen. I know immediately what it is. And she tells the governor, she says, I bought this for him so he could sign his oath with this pen. And the governor turned to his lawyer and said, go prepare new sets of oaths. So the lawyer came back 5 minutes later with new sets of oaths, and I signed it with the pen. But I say that because that's what she is. She is the reason why I get up. She's the reason why I do what I do. And I used to be embarrassed about being emotional about it. And I guess I still am a little bit, but I am emotional about that because of all the gifts in my life, she is the gift I didn't deserve.
Thank you, Bill Koch, for sharing your life experiences to date. And I hope in 20 years to be able to follow up on your next experiences.
Thank you.